Uh, Thank you for tuning to our channel, African Dignity. I have been asked by Dr. Naidu to stand in while she is on a sabbatical. And I hope that we will have a productive class where everybody will understand what is required of him or her. I am not going to start from the beginning except for brushing over so that I make sure that we are on the same wavelength. You have dealt with the introduction to the history and theory of law evidence as contained in your course outline or study guide. Mine is just to gloss over and make sure that nobody is left behind before we start with the next chapter, because I understand that you have gone to as far as lesson 6 or chapter 6 of your course outline. So I will continue from there, but before we get there, I just want to make sure that everybody is in the same page, because I have noticed that there are some of you whom are comfortable with being taught something and you don't help yourself by reminding yourself of what was said in class. You just learn to forget, and that is very dangerous for a law student to do that. But anyway, let us not chastise each other. I am hoping that each and every one of you will now pick himself up and let's get going so that you finish your studies. You are now on your final year. We should not be reminding you that you are on your final year, and it is very important for you to grasp everything, because that is what you're going to be doing next year when you do your articles or when you do your PVT, right? I was disappointed, to be honest with you guys. I was disappointed to see that people cannot interpret a citation. If I say, for instance, the case of Mangwanyana is 1995, 3 at page, and I state the page 141. People don't understand what is meant by 1995. People don't know what is meant by 3. People say 1995 of 3. You cannot cite a case like that. When you're citing a case, like I've told you, 1995 will be the day that judgment was made, and 3 is the volume. What do we mean by a volume? A volume is a situation where publishers like Butterworth, like South African law reports, will gather judgments by various courts, right, and compile them into a book. That's why you will see those black books. And if you look at the spine of the book, you will notice that there is a year and there is a number. That number is called a volume. So that book, that whole book, when you talk of a volume, you're talking of that whole book, that it is the volume. So now you know what is a volume. It's a collection of all the judgments in that year And once they are compiled into a book, that those black books, that is a volume. So if I say go and read the case of Mankwanyana, you will go and look at all the cases that were published in 1995 at the library. The library will make sure that all the 95 cases are put in one place. 1996, 2000, 2020, and 2021, they are put in one place, in one line, so that it's easy for you to know that the case that you are looking for is in this range of volumes of cases. So it's easy for you to go to that. Then you will go to all the 1995, and then you will look for number 3, which is volume 3, on the spine of the book. The spine of the book is the back part. The back part of like your back. You know, where is your spine? Your spine is right at your back, where you cannot touch, where you cannot scratch with the onion. That's where the spine is. Inside the spine, there is a spinal cord, right? So the spine of the book is the back of the book, right? And you will see it's written 1993, and then there will be a number, which is volume 3. Then that's how you are going to find it. So those are the things that you should have learned and not forget on the first day you came to university. So we shouldn't be talking about those in our final year of studies. It's embarrassing, it's a shame, and I am thinking of placing some of you with the judges in the Constitutional Court. But if you don't know volume, how do I start doing that? Because I'm going to embarrass the university. You will be sent by a judge to go and look for a case of Mankwanyana. If the volume is 3, and you won't know what is that, because you don't know what is the meaning of the volume. It is very important for you guys to know these things. It is important for you guys to know these things and make sure that you get familiar with it and you do not embarrass the university. Also, ex parte, we talk of ex parte. People don't know what is meant by ex parte. If I say ex parte so-and-so, a case that is cited as ex parte, people don't know it, and also that is also embarrassing. Ex parte will mean a case where there's only one party. A very good example, it is where you will be applying to be admitted as an attorney. You will make what is called an ex parte application, right? So please do not forget that. If you are not sure of anything, come to Dr. Naidu, and she has given you times where you can book an appointment with her, go have a one-on-one. You can also come to me while she's on sabbatical, and let us clarify whatever you don't understand when it comes to law of evidence. Law of evidence is a very easy course. Everybody is expected to pass, because it is just simple, the rules that you need to follow when you deal with evidence in court. So I think that is clear for now. That is very clear, and it shouldn't be a problem at all. So students, let us carry on with the gloss over, just to make sure that everybody understands what we are about. Like I've said, you've dealt with the introduction to law of evidence. So we know that law of evidence can be classified as adjectival law. So do not ask me what that is, because I've told you in class that each time you come across a word that you do not understand, it's either you will come to me and ask, or you will consult you can go to YouTube. There will be lecturers there telling you, law lecturers are abundant in YouTube. And you can also go to Google and ask a question as to what is meant by adjectival law. Substantive law as well, you need to know what is the difference, right? The law of evidence is linked to so many disciplines or areas of law. It is linked to civil procedure. When we are dealing with civil procedure, that is now cases where there is a plaintiff and there's a plaintiff and a defendant. There's an applicant and a respondent. Those are called civil cases. And then also criminal procedure cases. Those are cases where there is state versus so-and-so. Those are criminal procedure cases. Right. The English law of evidence, it serves as common law for the South African law of evidence. So we need to know what is meant by common law, because even in common law, the rules of evidence apply. So everywhere there is litigation, you will need to lead evidence. You lead evidence to support your argument, or you lead evidence to rebut allegations against you. Here in South Africa, we have what is called accusatorial procedure of litigation. What do we mean by accusatorial? In our case, we will have the prosecutor preferring charges on the accused. That is accusatorial. Inquisitorial procedure is where, for instance, in France, the presiding officer, that is the judge, is the one that does a lot of questioning, seeking clarity, and making sure he is dominus litis, in other words, unlike in our situation where the prosecutor is dominus litis. So he is the one that's preferring charges, is one that's alleging all the accusations against the accused, right? So that also you need to understand that when you do that, you will need evidence. If you accuse someone of having killed another person, you will have to lead evidence to the fact that here is the murder weapon, for instance. Here are the witnesses, eyewitnesses who saw the person committing that offense, that kind of evidence. And if you are being accused, you will have also to lead evidence as an attorney for the accused, lead evidence to rebut that by things such as alibi, where you will say, no, my instructions are that the accused was in Johannesburg. Here is evidence. Here are people whom he was busy partying with during the time when the deceased was shot. So you adduce that evidence. So alibi will be another kind of evidence that you can adduce in court in order to rebut accusations against your client. Right? It is important for you guys, students, to read. Right? You must read and make sure that there is nothing that you left to chance. When you come across any word, anything, any concept, any principle, you need to know what it means. Don't just leave it and say, you will catch up as you go along. It doesn't work like that. You've got to understand concepts, and especially the basic concepts and distinctions when it comes to the law of evidence, right? So there will be concepts like factor probanda, right? You need to know when you say factor probanda, those are the concepts that you are going to be hearing when you come to court. And don't be lost when somebody says factor probanda and you don't know what it means, right? Those are facts in issue which need to be proved, right? Facts in the issue. If somebody says, if like I've said now, if your accused is your client is accused of killing, then there must be facts to prove that he is the murderer. Things like DNA, that DNA was found in the house. His DNA was found in the house, or it was found on the body. A murder weapon, let us say a firearm. Firearm was found, and the bullet that was found on the deceased matches the ballistics of the firearm. You need to know what we mean by ballistics as well. Firearms like fingerprints have got lines in the barrel. The barrel is that part where the bullet is ejected from the gun. Inside that barrel, there are lines. Those lines are like fingerprints. They are not the same. Each gun has got its own unique lines. Those are called ballistics. Those lines are the one that propels the bullet to move faster. It moves on those lines, and then when it moves on that, it leaves a mark on the bullet. So you will see that type of marks on the bullet, and that's how you will see it. Or this is the bullet that shot so and so. It can never be the same. Each firearm has got a different ballistics, right? So, but now there's an exception to that. Some firearms, only the firearms called shotguns. You know, those shotguns that police use to disperse crowds, and you'll see their cartridges are red or green cartridges that have that are made of plastic. Police use them to disperse a crowd. Those firearms do not have these unique lines that are called ballistics. So when anybody deals with when your case involves people, when your case involves a shotgun, somebody was killed by the use of a shotgun, then you must know that you cannot say this the person was killed by this particular shotgun. It's impossible to determine unless somebody adduces evidence that shotgun was found in his possession, or the person was caught on the act while shooting the other person and he was caught with that shotgun. Maybe you can use that evidence. But if somebody shoots the deceased with a shotgun and he goes away, goes and hides it, and after a while that shotgun is found and the shotgun is linked to the death of the deceased, it's very unlikely that you can use any scientific method like ballistic reports to ascertain that the same shotgun was used in killing the deceased, because those pellets that come out of the shotgun do not leave any marks, because the problem with the bullet, with the shotgun bullet, is that it is full of small pellets like marbles, but they are made of steel. Those are the ones that fire and kill a person. And another thing, you cannot kill a person with a shotgun at a certain distance. You've got to be very near when you shoot somebody with a shotgun in order for that person to be fatally injured, right? So you need to know that kind of evidence as well. That is called forensic evidence. Okay. And then there is something called factor probantia, right? When you are pronouncing Latin words, you must always make sure that you read it phonetically, like how they appear. You can't say factor probantia. You say factor as it is, not factor. Factor probantia. So this means the facts that are necessary to prove the facts in issue, right? Or you can say facts that are relevant in issue, right? Okay, so all I'm trying to emphasize is that when you come across concepts that seem peculiar, or that seem that you do not understand, you've got to take a moment, research, and make sure that you understand every part of it, right? So evidence may be led in many ways. There's something called oral evidence. That is where somebody is brought to court and states his case to say, this is what I saw, right? And that evidence has to be made under oath. If as a presiding officer, because many of you will end up being judges, magistrates, prosecutors, you make sure that if somebody is called as a witness, that person has to be sworn in. That is, now state whatever he states, it should be under oath. So oral statement must be made under oath, or they can be made in what is called affirmation. If somebody says, I don't believe in God, I believe in something else, you can make an affirmation. A person can be warned, right, that what the evidence that he is going to give should be the truth and all of that, right? There is also evidence. There's evidence, oral evidence. There is documentary evidence, right, and real evidence. Documental evidence will be something like the fact that fingerprints were taken, and there is a chart of the fingerprint that was taken on the walls, or the fingerprints that were taken on the dead body, or on the weapon that was used to kill the deceased, right? Then there will be documents to that effect. But there's also documents like, for instance, the easy one is a bank statement. A bank statement. If somebody says, I was hired to kill so and so, right, and I was paid 50,000 rand, and what will happen is that the investigating officer, right, sometimes called the IO, will go and make an application to court in terms of section 205 of the Criminal Procedure Act, where they will go into your private bank account to go to the bank and ask them to print a statement on a particular amount. If somebody says, oh, I was given 50,000 rand by the accused to go and kill so and so, and I was paid on the 16th of March 2023, then the IO will have to go to the bank, and after having obtained an order from the court in terms of section 205, go to the bank and obtain a bank statement and see the transaction on that day. If really that transaction is found, to that the accused transferred a sum of 50,000 rand to the killer, right, who is now a witness in court. Then we've got documentary evidence that says indeed this what the witness is saying is supported by documentary evidence, right? So so I hope that everybody is clear with oral evidence and documentary evidence. Okay, now there will also be something called real evidence. Real evidence is a situation where the body or the gun that was used in the commission of the crime is put on the table in court to prove that this is the gun that was used, this is the knife that was used to kill the deceased. That is now real evidence, or evidence where the accused is sent to go and point out the firearm that was used. So police will normally take pictures of that pointing out, or maybe a video of him digging for the murder weapon or digging the body to say this I killed this person and I buried him here, and then we'll start digging, and that evidence will be found. That is now real evidence. So far I think everybody is clear and we understand. I don't think there's any problem with distinguishing those three types of evidences, right? So we said the oral evidence, the real evidence, and also documentary evidence. Okay, so I hope everyone is clear. Okay, there is also what is known as probative material that consists of oral, documentary, and real evidence, as well as formal admissions, judicial notices, presumptions, and plea explanations in terms of Section 115 or Section 112 of the Criminal Procedure Act. That also is another evidence, right? That it could be used in a trial, right? It's important for students to read cases that have been given by Dr. Naidu, and also I want to stress that make sure that you understand all the concepts that has been used in those cases. It is very important, right? Now let us come to what is known as the sources of the South African law of evidence and the impact of the constitutional provisions, right? We will deal with that in my next video. For now, I think this is enough. So go and digest it and make sure you understand everything. Then we will take it from there. But everyone should be in a habit of going to check on the African dignity. I will specify those videos as law of evidence and stroke Dr. Naidu. So you will go and then I will say what the chapter deals about. Then you can go and do it.